Welcome to my video on sexual harassment in the workplace. If you like this video, click like and subscribe, and remember to click on the bell. So now let's take a quick look at some sexual harassment statistics. In a Quinnipiac University survey, they found that 60% of women have been victims of sexual harassment, and close to 75% said it took place at work. In another study in 2017, they did a poll and found that 33 million U.S. women have been sexually harassed at the workplace. Now, do you still think that sexual harassment is not a big problem? Well, since 2010, employers have paid $700 million for harassment allegations made through the EEOC. Now, this number is staggering, $700 million, but it doesn't even include the federal employees who file lawsuits or cases against other federal employees, and it doesn't include any private lawsuits. So the numbers are staggering, and this is a big problem in the workplace. Now let's take a look at the definition of sexual harassment. Sexual harassment, as defined by the EEOC, or the Equal Employment Opportunity Commission, which is the government agency or the federal agency that has purview over sexual harassment under Title VII. They say sexual harassment is unwelcome sexual advance, requests for sexual favors, and other verbal or physical conduct of a sexual nature, when submission of such conduct is made either explicitly or implicitly a term or condition of an individual's employment, or submission to or rejection of such conduct by an individual is used as a basis for employment decisions affecting such individual, or such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. Unwelcome is a critical term for sexual harassment, and it's defined as sexual conduct is unwelcome whenever the person subjected to it considers it unwelcome. The courts and policy should not get into the practice of trying to determine what is unwelcome. It is really based on a subjective standard, and I'll talk a little bit later about the objective standard. In order for it to be sexual harassment, we take a two-pronged approach to looking at unwelcomeness. So, in order for it to be harassment, it has to be unwelcome to the recipient or the observer, which is the subjective standard, and we talked about that previously. And a reasonable person would have to find the same conduct to create a hostile environment, which is the objective standard. For sexual harassment, the conduct must meet both a subjective standard of unwelcomeness and an objective standard of unwelcomeness. Now, how do courts view a reasonable person? Well, a reasonable person is comparing the conduct or the feelings of the conduct by two similarly situated individuals. So, for example, if an executive assistant is making a complaint about conduct directed towards her, for example, from her supervisor or manager, the conduct will be viewed through the lens of someone who may be in a similar type of position and female. More on the definition of unwelcome in terms of unwelcome sexual conduct. Unwelcome does not mean involuntary. Conduct can be unwelcome even if the recipient does not say anything. The recipient may even appear to go along with the behavior or conduct. I didn't know is typically not a defense. Conduct may be deemed harassing even if it's not directed towards the person who views it as harassment. There are three basic forms of sexual harassment: quid pro quo, or this for that sexual harassment, which are actions by a supervisor or a manager that condition the receipt of a benefit upon sex or punish a person for not accepting sexual advances. A hostile environment are actions by others that create an abusive environment. This can be verbal, nonverbal, or physical. Third-party sexual harassment or favoritism is situations involving employees who are denied benefits or are penalized because of sexual attention directed at a favored employee. Here are some examples of quid pro quo or this for that sexual harassment. Better working conditions or assignments in exchange for a sexual relationship. Reduce or diminish work conditions or assignments when a sexual relationship is refused. Using physical or psychological coercion to force sexual relationships or as retaliation for refusal of a sexual relationship. A hostile environment can result from physical contact, verbal comments, nonverbal actions, or a combination of these. It must reach a certain level of severity or persistence or pervasiveness to be considered sexual harassment. Hostile environment physical conduct examples include touching any part of another person's body, especially in a suggestive manner, back rubs, neck or shoulder massages, sexually suggestive or lewd gestures, cornering, trapping, or blocking another person's path, stalking or following another person, attempted or actual sexual assault. Hostile environment verbal comments examples include remarks about physical characteristics, appearance, or attractiveness, remarks about sexual activity, sexual jokes, comments, or innuendo, repeated requests for dates, propositions of any type. Examples of hostile environment nonverbal actions include displays with sexually explicit or graphic content, unwanted personal gifts or attention, obscene gestures, ogling, leering, sexual or amorous letters or romantic letters, notes, emails, social media postings, exposing oneself, or masturbating. Here are a few questions I would like you to think about as you continue through this video, and drop me some comments or respond to these questions in the comment sections. Number one, how do you think the Me Too movement has impacted how we view sexual harassment in the workplace? Does sexual harassment have to involve sex? What about non-sexual harassment? Do you think this is covered as well? Can someone sexually harass someone of the same gender or sex? Okay, just a quick note. Let's talk about harassment by visitors, contractors, or guests. There are often people present at your organizations who are not employees. Similarly, employees may visit other locations for their work. Employees do not have to tolerate harassment under these circumstances simply because the person committing the behavior is not an employee. Your employer does not have the option of ignoring any type of harassment or sexual harassment that impacts employees or the work environment. The obligation is to the entire company's workforce. So what this means is, even if you're sexually harassed by someone that is not an employee or a member of your organization, you still have rights to be protected by your employer. When looking at retaliation, retaliation is any adverse or negative action against an individual because that individual engaged in a protected activity. For example, filing a complaint or even participating as a witness in a complaint. Retaliation has a definition that's quite different from the textbook definition. So it's any negative action, like moving someone to a smaller office or not allowing them to participate in certain projects, or even termination is considered retaliation. For employees who experience sexual harassment, you can file a complaint about the situation as soon as possible, or you can report the conduct to your manager or supervisor or the equal opportunity officer. Additional options for responding if you feel comfortable are: you can tell the harasser the conduct is unwelcome. Keep a record of the conduct. State that you will report the conduct if it continues. And remember, this is if you feel comfortable. Here are some quick tips for employers. Create an anti-harassment and anti-discrimination policy. Develop sound complaint processes. Notify employees of your policy and complaint process. Train all employees. Provide separate or additional training for supervisors and managers. The reason for this is that employers can be held liable for sexual harassment that is engaged in by their supervisors or managers. Have an open door policy so that you can address low-level issues before they rise to the level of a policy violation. Take appropriate action during and after a complaint. Investigate thoroughly and impartially. Preserve all documents. Provide appropriate and consistent complaint resolutions. Now, for employees, always make sure that you're consulting with your human resource department and taking a look at your internal complaint process and procedures. But also you have an option to go to the Equal Employment Opportunity Commission, or EEOC. And here's the contact information for the National EEOC office. You can also go into their website and find out what is the appropriate regional office based on your location. Hi, I'm Dr. Robin Kelley, and I'm the president and founder of Kelley Consulting Firm. We're located on Liberty Rose Drive in Mooresville, North Carolina. We can be reached at 716-907-7194, and there's our email address, info@kelleyconsultingfirm.com, or for more information and resources, please visit our website at www.kelleyconsultingfirm.com. Thank you so much for watching this video. If you like this video, click like and subscribe. Remember to click on the bell, and also don't forget to share this video. If you like, leave me a comment in the comment section on what you would like to see in the future, or you can simply answer the questions that I presented earlier in the video so that we can have a nice discussion.